Welcome to the Courtroom Club.
Great to be diving into this. It's definitely a topic we see a lot of confusion around, and frankly, a lot of distress, too.
Absolutely. It's something that hits close to home for many South Africans. Today, we're doing a deep dive into a really serious aspect of sectional title living. The power a body corporate has to actually force the sale of your home if levies go unpaid.
Yeah, that's the stark reality. And look, it's true, they do have that power, but, and this is critical, it's not like flipping a switch. There's a very strict legal process they absolutely have to follow. It's a gauntlet, really.
Okay, so our mission today is clear. We want to walk you through that exact sequence, step by step, from that first mispayment right through the whole legal maze, potentially up to an auction.
And importantly, we need to highlight where you can step in. What are those critical moments, those off-ramps, where an owner can act to stop things escalating? That's key.
Definitely. So let's start at the beginning. Why are levies treated so seriously? Why this, non-negotiable status?
Well, you have to understand, levies are basically the fuel that keeps the whole sectional title scheme running. Think about a shared cost, like maintaining the gardens, the pool, building insurance, security guards, communal lights, and water. It all comes from levies.
So if people stop paying,
The whole system breaks down. Maintenance stops, insurance could lapse, security might get cut. It affects everyone, and the value of every single unit can drop. That's why the law treats levy debt very seriously, almost like a mortgage payment or what you owe the municipality. You simply have to pay.
ignoring it isn't really an option then.
Not if you want to avoid serious trouble. And the body corporate can't just, decide on a whim to take action. There's a very specific path laid out in law.
Governed by the Sectional Titles Schemes Management Act, the STSMA, and the Magistrates Courts Act.
Exactly. Those are the rule books. The body corporate has to follow them to the letter. They can't just act on their own.
Okay, let's break down that path. Step 1.
Step 1 is always the formal demand. This is absolutely required before any court action. It's about fairness, giving the owner a clear, final warning.
So what does that look like?
Usually once you've missed payments, the managing agent or the trustees will send a formal letter. It details the amount owing and typically gives you, say, 14 days to pay up.
14 days. That feels like the last clear chance before things get legal.
It really is. If you can settle the arrears within that window, the whole thing stops right there. No major legal costs yet, no court summons. It's your best and cheapest way out.
But what if someone ignores that demand? Or maybe they just can't pay?
If that 14-day deadline passes without payment or a solid arrangement, then the body corporate moves to step 2, summons and judgment.
Okay, so now we're officially in the legal system.
Correct. They'll instruct their attorneys, who will then issue a formal summons. This is the start of the court case. If the owner doesn't respond to the summons, maybe they don't file a notice to defend, or they just ignore it, the court can then issue a default judgment.
And that judgment is significant.
Hugely significant. It's the court officially saying, yes, this debt is real, it's owed, and it's this amount. It transforms the claim into a legally enforceable debt. This judgment is what gives the body corporate the power to actually start enforcing payment.
Which brings us to step 3, I assume, enforcement.
Exactly. Step 3, getting a warrant of execution. With the judgment in hand, the body corporate asks the court for this warrant. It's basically an instruction to the sheriff of the court.
To do what?
To attach and sell the debtor's property to cover the debt, plus all the interest and legal costs that have piled up.
Now, does the sheriff immediately go for the house?
Good question. Usually no. The law generally requires the sheriff to look for movable property first. I mean, things like your car, furniture, maybe expensive electronics, or even investments. They try to satisfy the debt with those first.
Okay, so selling the unit itself isn't the first port of call?
Not always. But, and this is a big but, if the arrears are very large, or if the owner has basically ignored everything, made no effort to put out, or maybe doesn't have enough movable assets, then the warrant can be issued specifically against the immovable property, the actual apartment or townhouse.
Right. And this is where it gets, as you said earlier, really serious. Because even with that warrant against the property, they still can't just put up a for sale sign, can they?
No, absolutely not. This triggers the most critical stage, step 4. It involves a specific application to the court under Section 66 of the Magistrates Courts Act.
Section 66. Okay, what happens there?
The body corporate has to go back to court and specifically ask for permission to sell that specific immovable property, your home. And the court doesn't just rubber stamp this, it has to perform a careful balancing act.
Balancing what, exactly?
On one hand, you've got the body corporate's right representing all the other owners, Remember to recover a legitimate debt. If debts aren't recovered, the scheme fails.
And on the other hand,
On the other hand, you have the owner's constitutional right to adequate housing, which is protected under Section 26 of our Constitution. Losing your home is obviously a massive deal.
so the court has to weigh these fundamental rights against each other. How does that usually play out? Is the right to housing an absolute defense?
Not absolute, no. This is where a really important constitutional court case, Jaffe v. Schoeman, provides guidance. The court essentially said the right to housing is vital, but it doesn't automatically shield someone from the consequences of not paying their debts, as long as the whole legal process leading up to this point was fair, reasonable, and followed all the rules.
So due process is key. The body corporate has to prove they did everything by the book.
Precisely. They need to convince the judge that selling the home really is the last resort. Have they tried other ways to get the money? Did the owner have every reasonable chance to pay, to make arrangements, or to dispute the debt earlier?
What about proportionality? Does the size of the debt versus the value of the property matter?
Yes, the court often looks at that. If someone owes, say, 20,000 Rand in levies and the apartment is worth 2 million Rand, the judge is going to scrutinize that last resort argument incredibly closely. It might seem disproportionate, but if the debt is, hundreds of thousands after years of non-payment and accumulated costs, the balance might tip.
Okay. And if the court does grant permission under Section 66?
Then the sheriff takes over the execution sale. They formally attach the property. They publish notices about the upcoming auction. These have to be properly advertised and displayed, and then the auction takes place.
And this actually happens. People lose their homes this way.
Unfortunately, yes. It's not just a theoretical threat. We've seen it happen. Once the property is optioned, the money raised goes first to cover all the sheriff's costs and the body corporate's legal fees. Then, the outstanding levies and interest are paid off. If there's anything left over after all that, it goes back to the person who just lost their home.
Wow. So the key takeaway here seems to be that while the process is long and has safeguards, if you consistently fail to engage or pay, the system is designed to ultimately allow the sale.
That's it. The court protects fairness and due process, but it won't indefinitely protect someone from the consequences of ignoring a legitimate debt, especially when it harms the whole community of owners.
Right. Okay. Let's shift gears. What if someone finds themselves caught in this process? Maybe the summons has arrived or things are even further along. Can they still stop the clock? Can they prevent the sale?
Yes, you can intervene, but
Ah.
honestly, the later you leave it, the harder and much, much more expensive it becomes. Time is absolutely critical.
So what are the effective strategies? What's the first thing someone should try?
The absolute best strategy, even if a summons has been issued, is to try and negotiate a payment plan. Go to the body corporate, or more likely their attorneys or managing agent at this point. Be upfront about your situation.
Will they even listen once lawyers are involved?
Often, yes. Litigation is expensive and time-consuming for them, too. If you can present a realistic, affordable plan to catch up on the arrears over a set period and commit to paying future levies on time, many body corporates will consider it. They want the money, ideally without the hassle of a forced sale.
What makes a plan realistic?
It needs to be sustainable for you, but also clear the debt reasonably quickly. You might need to show proof of income or explain why you fell behind and how things have changed. Commitment is key. A vague promise won't cut it.
Okay. Negotiation first. What's the next option? The most direct one.
The simplest way to stop everything instantly is, well, to pay the full amount owing. Settle the arrears plus all the accumulated legal costs and interest up to that point. If you can do that, the legal action halts immediately.
Crucial tip here.
Get it in writing. Never rely on a phone call or a verbal assurance. Make sure you get a formal letter from the body corporate's attorneys confirming that the debt is settled in full and the legal action is withdrawn. Keep that proof safe.
Makes sense. What if the owner genuinely believes the whole thing is wrong? Maybe the amount is incorrect, or they think the body corporate skipped a step.
Then there's the option to formally object or appeal. This usually happens around the Section 66 application stage, or even before the auction. You're basically asking the court to review the process or the judgment.
That sounds complicated. Definitely need a lawyer for that.
Absolutely. This isn't a DIY situation. You'd be arguing points of law, maybe constitutional rights, maybe procedural errors. For example, was the notice properly served? Is the interest calculation correct? Is selling the house disproportionate? These are complex legal challenges and need expert help quickly before the sale happens.
Okay. Now, let's say the court agrees that selling the house is too harsh in a particular case, maybe for a smaller, more recent debt. Are there other tools the body corporate can use instead? Less drastic measures?
Yes, the court and the body corporate have alternatives. Probably the most common one, especially if the owner is employed, is an emoluments attachment order, an EAO. Most people know it as a garnishee order.
Right, where money comes directly off your salary.
Exactly. The court orders your employer to deduct a certain amount from your wages each month and pay it directly towards the debt until it's cleared. It ensures payment without making someone homeless.
That seems much more proportionate in many cases.
It often is. Other options could include, as we mentioned, attaching and selling movable assets, first cars, valuables. In some situations, the court might even allow attachment of funds in the owner's bank account, though that has its own complexities. The point is, Section 66 sale isn't the only enforcement tool.
Let's talk about the money again. This is where it gets frightening. You mentioned costs escalating. Can you give us a sense of scale?
This is the financial trap, and it's brutal. The rules under the STSMA generally state that the defaulting owner is liable for all the costs the body corporate incurs in trying to recover the debt.
All costs, what does that include?
It includes the body corporate's attorney fees, which rack up with every letter, every court document, every hour spent. It includes interest on the overdue levies, often at a high rate set by the rules or law. It can include collection commission charged by managing agents, plus administrative fees.
So a small initial arrears.
Can explode.
Yeah.
We regularly see situations where someone falls behind by, say, 6,000 Rand, maybe 3 or 4 months of levies. By the time it goes to demand, summons, judgment, maybe warrant application, that 6,000 Rand debt can easily become a 40,000 Rand debt, or even more, purely because of the added recovery costs.
That is a shocking increase. The cost of doing nothing or delaying is just massive.
Absolutely ruinous. It underscores why prevention and early action are paramount.
So let's nail down the best practices for prevention. What's the #1 rule?
Communicate early. Don't wait for the scary letters. If you know you're going to struggle to pay your levy next month, talk to the managing agent or the trustees now. Explain the situation.
Be proactive, basically.
Yes. Actively ask about payment arrangements before you're in serious arrears. As we said, they often prefer a structured settlement to expensive legal fights.
Anything else owners can do on the prevention side?
Well, know your rights under the STSMA. You have a right to see the body corporate's budget. Levies can only be set or increased following proper procedure, usually approval at an annual general meeting, AGM. If you think a levy is unreasonably high or wasn't properly approved, you have grounds to query it or even challenge it internally. Keeping levies fair helps prevent defaults in the first place.
And legal help seems essential on both sides here.
Critically important. If you're an owner facing this process, especially a Section 66 application, you need expert legal advice to understand your rights and options. And for the body corporate, using experienced attorneys ensures they follow the procedures correctly, lawfully, and effectively, protecting the scheme's financial health while respecting owners' rights. It avoids costly mistakes.
Okay, let's try and summarize the key takeaway for everyone listening today.
The bottom line is this. Yes, falling behind on your sectional title levies in South Africa carries a very real risk of losing your home. It's severe. However,
the process to get there is long. It's legally regulated with checks and balances, and crucially, it is almost always preventable.
exactly. Your most powerful weapons are talking early, sticking to agreed payment plans if you hit trouble, and generally being proactive about your financial obligations to the scheme.
So we usually end with a final thought to mull over, building on what we've discussed.
Here's something to consider, flowing directly from that Jaffa case and the last resort principle. If the courts require body corporates to prove they exhausted other options before trying to sell a home,
Then maybe owners, even those who are paying on time, should be more proactive.
right? How actively should you, as an owner, look into your body corporate's actual collection policies? Do you know what steps they take internally before sending that first formal demand? Are their communication strategies fair? Do their policies genuinely reflect that selling a home is the absolute last resort?
So auditing the process before anyone defaults to ensure it meets that standard of fairness and exhaustiveness required by law.
Precisely. It's about ensuring the system itself is fair and transparent, which benefits everyone in the scheme. Something to think about.
A very pertinent thought indeed. Thank you for joining us on the Courtroom Club. We trust this deep dive has given you valuable clarity on a complex but vital area of property law.